the H-1B program under attack and dealing with the onslaught. I think those of us who work in the U.S. immigration know there's been so many changes and challenges. Our trainer will be Purvi Chotani, who is a native here of India and also works from Mumbai office, right? She has local presence. Her and her team are triple licensed, India, US, and UK. All of these places, they have responsibilities to the bar of those countries where she practices, representing the needs of the companies and the people she works with. Understanding the local laws in all of these places is a great advantage. I wanted to mention that she has some special raffles at her table. The LawQuest table is found outside in the exhibition area. She is giving away 2 hampers of wonderful Ayurvedic products, both for men and women, in case you're concerned that it's only for the ladies. But go and put your business card there, and she will have a raffle, and you'll get some wonderful Ayurvedic products you can use for yourself or take to someone else that's very special to you. With that, I want to bring up Purvi to teach us about the H-1B under attack.
Thanks, Jake.
Yep.
Thank you, Jake. Now, to be called a trainer to a room full of experts, because I saw the poll, most of you are in this field of immigration since more than 15 years. So it's a challenge to train experts like you guys. So as we go along, if there are tips you want to give, I'm going to go a little out of what INSZoom wants me to do, and I'm going to field questions with Jake's permission. May I? Okay. So before we go into that high-tech question technology, I want to ask you in the room, how many people have worked on H-1B cases this past year? Just a show of hands, please. It's not the whole room, it's just 1/3, I would say. Thank you. And how many you have done, how many of those who just raised their hands have also done it in the past, in the previous years? So that's like about 2/3 of the 1/3. Okay. Anyway, so now the next questions are going to help us gauge your experience. So if we can have the questions, please. You can have the question. So have you had more denials than FY 2019 for your CAP cases? That's for FY 2020. And your answers are yes, 50, and no, 50. So wow.
There's only 2 responses so far, so coming back from break.
Right. Are you sure you guys don't want to think that again? Think that through again? Okay, that seems more realistic. Thank you. The next question, please. So have you seen more denials or RFEs on any of these issues? So the most of the challenging, the cases that are challenged are for the specialty occupation, followed by employer-employee relationship, with lack of available work and other coming together, and wage level. Okay, there's a bit of a shift. But anyway, it's predominantly because of challenges to the specialty occupation prong of the H-1B criteria. The next one, please. So this is to gauge how you all are faring with your RFE. So how many? More than 2 days, 2 days, 3 hours? So more than 2 days seems to be, thank you, seems to be the predominant answer. And I would say it takes us several days, because by the time we work with HR back and forth and we get the RFE responses together, it takes us several days. So the workload has increased for all of us than ever before, but the end result is the same, an H-1B approval. We're not getting anything more. Okay, guys, we can start with our slides now. So today what we're going to go through is we're going to address the challenges that we're facing just now and the change and look at some of the prominent issues that are trending. And then we'll just touch upon briefly the challenges that these H-1B issues are posing to the extensions of H-1B cases beyond the 6-year period. So we are mostly facing issues with specialty occupation, degree relevance, level 1 wages, employer-employee relationship, and post-6-year H-1 portability. Okay, so one thing, the good news is that the law really hasn't changed, because for the law to change, the government has to go to Congress to change the law. So the law hasn't changed. But what has happened is under the current administration, under the Trump government, lots of changes have taken place in the regulatory regime on how this statute is being implemented and enforced. So what are the changes that they've brought about by executive dictate or by policy changes at the USCIS? And these are the most prominent. Rescission of prior guidance on H-1B petitions for computer-related positions in March 2017. This really hit us hard for the CAP season at that time, because computer programmers at level 1 were almost as a blanket rule considered not to be a specialty occupation. The Buy American and Hire American executive order in April 2017. This is really not something that is a law, that they have to do this, but this is a diktat that has been given across the agencies. And what the agencies have then gone and done is they've tweaked their policies, they've tweaked their guidance to their officers. For example, the Foreign Affairs Manual, which guides the consular officers, have been changed. And everywhere these 4 words have come in and they've crept into the regulation. So in my view, what this does is, even though it cannot force an officer to just, say that or does not even give him the power to say that, no, this job can be done by an American when you go for your visa interview, what really happens, or what frequently happens in our experience, is that thought that this job could be filled by an American is at the back of the mind of the officer, and that colors the adjudication. However, we don't have any concrete proof of that, so we can't challenge it. Then we had the rescission of deference memo in October 2017. What this did was that prior approvals for candidates in the same position don't automatically get the deference of the officer to be approved for an extension. So at the time of extension, the petition is reviewed as if it were a fresh application, and so we don't get any benefit of the precedent that they have themselves granted earlier. Why did we go there? Okay. Then there was so all along we knew that when we posted our workers at third-party sites, we needed to show that they had an employer-employee relationship with the petitioner and several other things. But in 2018, February, they actually had a policy which says that we've got to prove with copies of contracts and a detailed itinerary about the job that the H-1B candidate is going to do at the third-party site. This has added a lot of burden to the petitioner, and it has also created other challenges, because when we are talking about contracts, we are facing problems with validity, and we'll go into this in detail a little later. Then one of the other ones which had a devastating effect was the power that the USCIS has been granted to refuse cases or refuse cases without issuing an RFE or a notice of intent to deny. If there is a critical flaw in your petition, so if you've not tick marked a correct box, or you've missed a signature, or you've missed a check, your petition can be denied. They don't have to give you a chance to correct it. So this one has created a lot of tension amongst the paralegal community and amongst the attorneys and the HR community, because you've got to be so much more precise. And I know of law firms that, as does ours, that we have 3 levels of review before a petition is sent out, because we don't want to miss anything. So let's start with the first issue. The first issue is specialty occupation. So what does the law say? The law says that a person can be employed in an H-1B position if the occupation requires theoretical and practical application of a body of highly specialized knowledge. And I'm going to skip that, and which requires the attainment of a bachelor's degree or higher in a specific specialty or its equivalent as a minimum entry to the occupation in the United States. So what does this mean? This means that the job has to be one that requires an H-1B, and the job has to be one that requires a person with a bachelor's degree, and the person should have had a bachelor's degree to qualify, and a US bachelor's degree to qualify for that job. Now, I mean, in the past years, we've seen that as long as you can prove that there is a level of complexity and the person has a bachelor's degree, they're going to be fine. But now they've become more strict in the way it works out. So, for example, if to prove a specialty occupation, we've got to prove any of the 4 prongs. Technically, if you proved even one of the 4 prongs, the USCIS has to accept it as a specialty occupation, but that's not how it works in practice. When they raise an RFE, they throw the whole statute at you and challenge your claim under all the 4 prongs, so it is actually good practice to address all the 4 prongs. And if a prong does not apply to your case, to explain why it does not apply to your case. Now, what are the 4 prongs that they want you, what are the 4 tests that they want you to meet? Is that a bachelor's degree requirement is an industry norm, and among similar organizations, employer normally requires a bachelor's degree, and the nature of the specific duties are so special and complex that the knowledge required to perform them is normally associated with a bachelor's degree. So you've got to prove all of these. It would be best to prove your case under all of these. Now, the OH is actually a double-edged sword. Sometimes the USCIS uses it as an ammunition against us, and we'll come to that a little later. But wherever possible, you should use it as a defense mechanism for your cases. So what happens is with the ONET jobs that are listed, the OH has got descriptions, and in many of them, or in most of them, it describes what the education levels are. But for the computer jobs, we're going to see that in one of the SOC codes that we still face a challenge, or we face a big challenge with the OOH. So the way we've been addressing this issue is by showing that the beneficiary's specific coursework is tied to his duties. We do a comparison of the 2. We submit organization and employee charts to show that others in the same position or similar positions all have bachelor's degrees. And we also show job posting of other companies in the similar field. I'm not going to spend so much time on how you try to prove this, because the next session is one on avoiding RFEs, and I don't want to overlap on that. The challenge of degree relevance, what the USCIS is doing is it's been denying cases on the relevance of the degree. And their challenge has been that this degree does not match the job, or this degree, I mean, anyone with any degree could do it, and it does not specifically need this job. And so the way you word your petition is very important. If you say that this job could be filled by a person with a degree in A, B, C, and D, or similar, you might be opening yourself up for challenge. So try and narrow it down as much as possible. But you also want to be careful because some of the Indian degrees that we use to qualify abroad, to qualify as a US degree, are very often named very differently and don't have an exact match to the degrees named in the OOH. So what we do is use an education evaluation, which many of you must be doing, and then try and narrow it down to that particular field that the person is going to be working in. So let me talk to you a little bit about the case law that talks about the degree relevance. One of the main ones is Residential Finance Corp, and this also touches upon other issues of specialty occupation. The knowledge and not the title of the degree is what is important. Diplomas rarely come bearing occupation-specific majors. What is required is an occupation that requires highly specialized knowledge and a prospective employee who has obtained the credentials indicating possession of that knowledge. So this is a case that you could very well cite and use to improve your petitions. Another relevant case is Royal Siam Corp versus Chertoff, where it says, although a general purpose bachelor's degree, such as a business administration degree, may be a legitimate prerequisite for a particular position, requiring such a degree without more will not justify the granting of a petition for an H-1B specialty occupation. So when you see the degree that is being challenged is business administration, because it's too broad. A business administration degree can be sort of used or can be tweaked or added upon to work in any field almost. Now there's another case called Tapis Intern versus INS, and this has language about equivalent degrees and not necessarily having a major for every job. Therefore, finding that the position was a specialty occupation, since an employer can show that it requires a certain type of bachelor's degree in addition to specialized experience or training. This one can be used in our favor to show that a particular type of degree is relevant. There are also case law that recognize occupations evolve over time, and a position that previously qualified as a specialty occupation may not be one now. That sort of has a direct bearing on a computer programmer at level 1 issue that we are facing. And then there are some older case law which have now actually become standard adjudication policies that the USCIS follows. Though it's not documented, they follow the case law, and then we are fine with that. What we found is that they're challenging the nexus between the degrees and the duties. So if you can walk through, if you can sort of analyze the degree, the coursework of the employee, and compare it to what his job is going to be, and how he is going to use a particular field of education or a particular subject to complete that job, that will help your case. So this employer-employee relationship. So the 2010 Neufeld memo was then replaced or added to by the 2018 USCIS memo, which now is actually added. So the 2010 Neufeld memo is not repealed, it continues to be there, but the 2018 memo makes it harder. So you've got to show that the petitioner has contracts, SOWs, service agreements, and work orders with end clients, establishing a petitioner's right to continue to control and the right to control the beneficiary's work. This is all very well when we have the SOWs and the MSAs, etc. However, what happens is that most of our IT companies especially have got contracts with companies that are on an ongoing basis. So they have open-ended MSAs and very narrow or very or SOWs with a brief validity. This creates a problem because it does not show availability of work, which is another issue that we will come to shortly. So yes, you should add these SOWs and MSAs, but do it prudently because you could shoot yourself in the foot if you're not careful about what you're including. Now, they're challenging the employer-employee relationship in many ways. They want you to prove that you're going to claim the employee as a tax, as an expense in your taxes. You're going to be giving the employee equipment to work at the third-party site. They want to know that you're going to be, the work product is going to belong to you, or the benefit of the work product is going to belong to the petitioner, etc. So the end client letter becomes very important, but we've also seen that the end clients or the third parties are very reluctant to issue these end client letters, and hence you've got to be creative and proactive in how you're going to address this by adding supervisor letters and other letters which will then, employment contracts, etc., which will then establish the employer-employee relationship. How much time have I finished? 57 minutes? Okay. There are certain petitions that have been challenged on the wage levels, and the memo that was issued in February 2017 really spoke about level 1 computer programmers. However, the USCIS has been using this level 1 challenge even for other job categories, and that is creating a real problem. So if your individual is really going to be working at level 1, it is important to document why that person qualifies at level 1. So, I mean, sometimes the employee has multiple years of experience, but when he goes into the American company, he's going to be working at an entry-level position. So emphasizing on his prior experience actually will not be a good idea. So things like that can be carefully addressed so that you can still qualify employees at level 1. And so then you have a double-edged sword here, because if you see the second point, it says that the employees perform routine tasks that require limited, if any, exercise of judgment. If we are going to emphasize that, then they're going to come back and say, oh, that means it doesn't require a bachelor's degree, so then that's not a specialty occupation. So you've got to be careful about how you address that. So even the other points, like the employee may perform higher level work for training and development purposes, you can talk about all of that so that you can say within the next 3 years we expect this person to be operating at level 2, but at the moment he's only going to be pegged at level 1. These employees work under close supervision. That also you can use that as an advantage to prove level 1. But again, you've got to be careful, because if the employee does not have any discretionary or decision-making powers or powers to influence the work of a project or contribute to the work of a project, you might get stuck with the level 1 argument. So one way in which you can effectively set up an argument for the department, for a level, the level 1, or any level actually for that matter, to determine prevailing wage, is to use the Department of Labor's worksheet, which helps you. It's got a grid. It talks about the job duties, years of experience, etc., and it allows you to justify or to determine what level that person comes in. And in certain cases, it's a good idea to do that working and include it in the petition. Thank you. Thanks so much. So there are just some pointers that would help you there. They are part of the supervisor letter that I had spoken about earlier. Now, there are some occupations that are under attack more than others, and we've identified some of them which have a predominant effect on the companies out of India. So most of them are business occupations. This actually has a bearing on all industry jobs. And then the next one is IT occupations, where the occupations that are being challenged are computer programmer, computer systems analyst, web developer, software developer. The one that faces the worst challenges is computer occupations, all other under SOC code 1199. And this includes high-level positions of software quality assurance engineer, computer systems engineer, information technology project manager at all. So it absolutely is baffling how the USCIS expects those complicated jobs to be done by somebody without a bachelor's degree in a related field, but they do challenge it. So these are more details on the occupations under attack. And again, can I have a show of hands whether anybody in the room has faced faced issues with this code, SOC code 1199? Not too many? Okay, just 4 or 5 in the room. Can I have a show of hands and how many people do use this code at all? Very few people. Okay, great. Some of our clients use this code very frequently with good success. So you might want to consider it. This is more details on the occupations that are under fire. Can I have a show of hands in the room? Have you all faced issues with these job codes? Not too many. Okay. Anyway, so what does the USCIS do? They keep going to the OH and challenging that if the OH does not clearly say that this person requires a bachelor's degree to fill this job, then they have then they're challenging it. But what you need to do is you need to then go to secondary resources also maintained by the government, like the career. Just give me 1 second. I've got a list of them for you. So you can refer to their own resources and prove that these are specialty occupations. One is Career One Stop. The other one is usajobs.gov. The other one is the USCIS's own H-1B Employer Data Hub. You can also refer to the Department of Labor OFLC performance data and the Department of Labor's Labor Certification Registry. The other source that is not a government source, but it's a Mathematics and Engineering Computer Science report that it is published by the US Department of Commerce that also has got great information on how, for example, a maths degree would be absolutely relevant for a computer-related position. There are non-government resources like Explore Health Careers, etc., for health-related careers, but that does not probably apply to this audience. One thing that we notice is that when they challenge the OOH data and they say that this is not normally required in the industry, that's the word that is used. How do you define normally? You know, you start with the dictionary. What is the definition of normal? And then you go through the percentage of the OOH survey that they have got. They've got the data that they've got after surveying companies, and you see and you add up the total and you will see that in many of the jobs we listed earlier that the majority of the companies require a bachelor's degree. So does that not make it normal? I mean, that's the type of argument that you should be building upon. So this slide I'm not going to spend too much time on, but there is the law that allows the H-1B visa, which is usually valid for 6 years, to be extended beyond the 6-year period in certain circumstances, like when they have an approved green card, either an EB2 or an EB3 petition, and they can then port their job to other employers. What is happening is that this portability also now is getting affected. There are policies also that have changed the way this portability will work, but even the H-1B adjudications, like I said, the deference memo is creating problems to the portability and to the subsequent extensions, even when they have approved green cards, creating a lot of chaos for many families and companies. So avoiding and addressing RFEs, I'm not going to speak about this. My colleague Anandita is going to speak about it after this, and I will leave it to her. So the only one piece of advice I want to give you all to prepare for the next year, because we really don't know how it's going to work, is to be prepared. And we're going to speak about how the pre-registration, etc. is going to work. We're going to speak about that tomorrow, so we can deal with that separately. But otherwise, it's really important to gather your documents, strategize in advance, and be sure you include all the evidence you can right in the beginning, and be sure to remind the USCIS that the standard of adjudication is preponderance of the evidence and not clear and convincing. Many of the non-lawyers in the room may not understand what this means, but this means a big deal, because what this tells the USCIS is we've got to only prove to you that this is reasonable and not we don't have to meet the standard that we have to prove that a person is a murderer. We don't have to do anything like that. Anyway, so may we open it for questions, or do you have questions?
So one of the options on the Slido app is to pose questions that can be posted. So if you want to bring the app, you have some questions for Purvi, that would be great. You can post a few, she can answer, and then we'll have a quiz on some of the content that she presented to you to see who was really focused.
I think it's the quiz, Jake.
Seeing the questions. Are people posting some questions?
Maybe not.
No? Maybe not. All right.
The quiz.
Purvi, thank you for presenting to us and giving us, what's that?
May I get off?
Yeah, come down. Come the safe way down the stairs. Thank you, Purvi. You're welcome. If you do think of some questions, we'll post them to her. Oh, they're coming. Purvi, wait.
Okay.
Questions are coming.
I have a mic here so I can answer.
Awesome. So these are questions that are starting to come. Now, if you see the question in your queue and you like it, you can click it. It will come to the top and she'll see it.
Okay, I have not understood now what is question 2, but the first question is, how is the new flag system, especially all certified LCR, getting deleted within 7 days? You should bring this up to the Department of Labor's notice, and there are public forums, public emails where you can write and explain to them. But if any of you have access to the American Immigration Lawyers Association or its members, you should bring this up to their notice, because they are taking feedback and working upon it. The USCIS Liaison Committee at AILA is very actively working on this, and that is a problem. So please bring it to the attention of the government. Then, how do we justify a case with business administration degree? So for example, if this person has a business administration degree and has been working in technology solutions for the banking and finance industry, that's a very good case, where you could do the education cum experience evaluation and say that his hands-on experience working on solutions where he applied his business knowledge has now brought him up to the level of a US bachelor's degree in business computer engineering or similar. So you could do that. We have used that successfully, but you need to get a very good evaluation done. What you also need to be aware is sometimes the evaluators will just churn out what they normally do, but you should read it, and if you think that something needs to be highlighted or something needs to be added, you should go back to the evaluator and request them to do that, because your understanding of the beneficiary's background is better than what they can understand based on the documents you provide. So yes, it's possible to do, and you can do it carefully. Okay, what do you think about I-140 approval considering current administration? We've not faced any problems with I-140 adjudications in any of the categories that we use for business. We haven't faced any challenges as yet. If you all have faced challenges, I'm happy to discuss them with you offline. But I don't have any experience with, we don't have any experience at the moment with challenges to this. 6-year limit on I-140 approval and filing extension based on its approval. Correct, so that's, you are allowed to do that. So I don't see what the question is over there. Why was the public charge rule enforced and later cancelled? So the public charge rule has not been cancelled. It is only, there's only an injunction against it, or a temporary restraining order against it. So it's not as if it's final, it's been abandoned. And one thing you need to remember is the public charge regulations largely affect the family-based immigrants and the refugee and asylee cases, they don't generally affect the business workers because employers are obliged to give you insurance. So you are very unlikely to have used public funds for any services, or any services in America could qualify you as a public charge. So the statute, the order has not been cancelled, it is just temporarily stopped. What should be the plan on CAP? To draft, keep it ready, or wait after Okay, so we are going to talk about pre-registration and whether it's coming or not tomorrow. There's a whole panel on that and other issues with the H-1B. But the short answer is, I don't know. And I don't think anybody in the room knows whether pre-registration is coming. However, I was recently at a conference in London where there were a whole lot of leaders from the immigration community talking over there, and the consensus with these, and these are all past presidents or current presidents of AILA, and the consensus amongst them was not likely to come before FY 2020. So the online pre-registration, according to them, is not likely to come before 2020. We have no idea. We have to wait and watch. My advice would be in some level of preparedness to file the paper applications for all your candidates, because you don't want to be caught by surprise. Will there be change in visa lottery process? How should we prepare? So the change in the visa lottery process has already been announced. What they're going to do is they're going to run the lottery on the US master's cases first and then the general bachelor's cases. So the people with the US master's degrees have a 16%, by the USCIS's calculation, a 16% advantage of being selected in the H-1B lottery. So I really don't see what you can do to prepare for the change in the way they're going to run the lottery, but in the way you're going to do either pre-registration or not, in that you can be proactively prepared by preparing your documents up to certain levels. What are the preferable occupation codes to be used for IT developers, IT roles, given the current onslaught on codes like software? The answer is it depends. You've got to see their job duties. There are many other codes out there that you could consider. One of them, like I told you, some of our clients very successfully use the SOC codes under 1199. So you should look at those, but there are many others. I'm sorry, I'm not able to answer which is the best because it depends. It depends on the job role, it depends on the project requirements, the person's exact duties, etc. What will the H4 rule get enforced next year, which was raised by Trump? Maybe. We don't know. We don't know. But that's another way they are attacking the H-1B program, because what's happening is that all those I-140, all the H-1B workers who have the post 6-year extensions because they have approved I-140s, their spouses were eligible to get the H-4 EAD cards or the work authorization. Now, by closing that down, that's also another backhanded attack on the H-1B program. So we don't know. There is a good chance it might be cancelled, but we really don't know. Do you see any trend emerging with premium versus regular filing? I always love premium processing. And why do I love premium processing is because there's a way to communicate with the USCIS much more efficiently, and you get a response much more quickly than if it is regular process. I don't think it has any bearing on how the case is going to be adjudicated, but of course you're going to get a quicker response. That's within 15 days, so you're not stuck with the uncertainty of several weeks or months, which according to me is a big business advantage, because you know you're going to get your employee there or not within 15 days. That's a big advantage. Or even if it's an RFE, quickly, you'll know quickly. But the bigger advantage is the communication with the USCIS. So simple problems like a misspelled name on an I-797 approval notice can be corrected quickly if the case had been premium processed than otherwise. Several things like that. I mean, there are many ways in which you can communicate and correct things if you do premium processing, but clients don't like to always do premium processing. I wish they would. Now we come to the next. I can't answer that one, so we're going to the next one. USCIS started asking office space pictures. Some clients are, so no, nothing is mandatory to share with the USCIS. It's all up to you. The more you give them, the more likely you're going to get the result you want. So if possible, do give them those pictures. It really doesn't harm you. But no, the answer is you don't have to give it to them. Is break in employment is acceptable for L1 if employee has been employed for more than 6 years and rejoined after a year break? Yeah, I don't want to comment on the first one, the one about Wipro and INSZoom. I'm sorry, I'm not going to comment on that. I'm going to take the next question about the L1. The L1 criteria is very simple. You need to have qualifying employment for the period of 12 months in the preceding 3 years. So a break and coming back should not affect it as long as you have the 12 months of qualifying employment within the previous 3 years. Yes, there seems to be, sorry, excuse me. So there seems to be an attack on these asylee applications also. However, I don't do any asylum cases. All I know is what I hear from my colleagues. But yes, it is under a lot of pressure, and that class of the immigrants was really the worst affected by this public charge rule that the government wanted to implement. So the answer to that question, should we put everything in the initial petition or save something for the RFE? I would say you've got to strike a balance. I would actually give everything I can possibly give in the initial petition, but save 1 or 2 nuggets for the RFE. You've got to decide on a case-by-case basis. But that's the strategy I would like to use, because many cases of ours get approved with this strategy right at the initial stage. So, there's no harm. But of course, be careful. No critical information can be missed out, because otherwise they can deny without an RFE or a NOID. Is the USCIS getting the point-based system sooner? I don't think that's coming anytime soon, because every time Congress goes to discuss immigration, in addition to the highly skilled migrants that they want, they always are fighting about the wall on the southern border, and then they're fighting about the legalization of the 11 million undocumented immigrants within the country. So all these 3 things are clashing because the interests are different, and I don't see this thing being resolved anytime soon. Okay,
awesome. Perfect. Thank you.
Thank you.
Great. Appreciate all the extra information we got from the questions, and thank you for the questions that you posted for Purvi. So now comes the test, if you were listening. Get out your Kahoot app, get ready. We don't want to spend too much time just logging in here, so enter in the code